Can you tell us your view of the function of the qualified immunity doctrine and the practical consequence for our society of having strong qualified immunity laws?
Qualified immunity is a disaster for civil rights plaintiffs in most areas and for all civil rights plaintiffs dealing with police abuse. Qualified immunity is an invention of the court. It is superimposed upon 42 U.S.C. Section 1983, which says the following, and I quote, "All persons, every person, who under color of any statute, ordinance, etc., subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the constitutions and laws shall be liable to the party injured." There are no immunities included in Section 1983. And perhaps Justice Gorsuch, who recently decided that Title VII includes same-sex marriage, same-sex employment protections, because that's what it says in the statute, might want to revisit the words of this statute. What the court did was superimpose upon this categorical imposition of liability for violation of rights an immunity intended to serve two principal functions, and they are articulated in the decisions. The first was to free state actors to act, because as we all know, our public servants act in our best interest, and they shouldn't be afraid to do so. And the second is to do something about frivolous lawsuits. I'll say a word about each of those two factors. With regard to the question of making people free to act without being in fear of being personally liable, Carol Schwartz, a scholar of these matters, has done an empirical study of police cases to assess what percentage of cases involve actual payments by the officers of 1 penny. I think it's less than 1%. And we know here in Virginia, most police departments and sheriff's departments receive indemnification or insurance through the Division of Risk Management. Their organization purchases effectively insurance, and anybody who does that litigation is well acquainted with DRM or the equivalent outfit that provides that insurance. I've sued many officers. I have never had one had to pay 1 penny for his defense or for damages or for settlement. So with the evolution of protections to our public servants, the rationale for permitting people to engage in their work freely without impediment or fear, really, it doesn't hold water. The second justification is to save the system from frivolous lawsuits. Here we do with qualified immunity what we do with lots of things in law. Because there are numerous problematical cases, we establish a Procrustean bed that controls all litigation. So, for example, there are lots of lawsuits filed by prisoners. Lots of them are frivolous. The response to that is not to have judges act on frivolous lawsuits, but to pass the Prison Litigation Reform Act, which almost demolishes the capacity of prisoners, any prisoner, no matter how good, how strong, how righteous a claim, to obtain damages, gives them procedural hoops to go through, modifies dramatically attorneys' fees, which makes it very difficult for prisoners to get lawyers. And that happens to the good suits, the righteous suits, as well as the suits that could well be dismissed. Same thing happens in, if you will, so-called tort reform, limit on punitive damages. Yes, there is a need to control inappropriate verdicts, That's why we have judges. That's why we have remitter. But what the legislature does instead is to chop off everybody's head and make it impossible for people to obtain truly compensatory and, in appropriate case, punitive damages because of the general rule. That's what happens with qualified immunity.